Good morning again. My name is Liz Stallard, and I'm happy to welcome you to our annual employment law briefing, 2021 and onward. With me today from our employment and labor practice are Cass Ferrannini, a partner in our practice, and Alex LaFountain, a senior associate in our practice. And we're all very excited to tell you about the new changes we'll all be dealing with in 2021. We will make you both happy and sad, I think, by the end of this briefing, knowing all the things that you're going to have to deal with in the months and the year ahead. Just some housekeeping before we get going. First of all, there is a Q&A available, and please use that feature to ask us questions during the webinar. We will do our best to answer them as we go through our various sections of the PowerPoint, but if we don't get to your question, or if there are additional questions at the end, we're going to save some time to cover them then. So please be patient with us as we try and do two things at once. We also will be sending out the PowerPoint presentation that we're walking through today, as well as making the webinar itself available after today's presentation. So if you have any questions about that, we will be able to send that out to you. And then also, for those of you who may be looking for certificates of participation in this program to get various credit, if you need one of those certificates, please reach out to Mary Isley, and she will go ahead and give you the information you need and get that to you. So with that, I believe we are ready to go ahead and get started with our annual employment law briefing. So just to start, give you a brief overview of what we'll be covering today. First, and perhaps foremost on everyone's mind, we're going to talk about COVID-19 for 2021, reporting requirements, paid leave issues, workers' compensation, and vaccination. We will talk about the expanded leave obligations that are coming in 2021, including protections under our California Family Rights Act, or CFRA. We'll then move into discrimination, equity, and inclusion issues. We'll cover the reprieve we've received under the California Consumer Privacy Act. And then finally, we'll end with an update on wage and hour issues. And with that, I will turn it over to Cass to get us started.
All right, well, I just gave you the meaning of the universe in about 30 seconds. Sorry about that you missed it all. But I'll try to recreate it now. So COVID-19, you can't get enough of it. So here we go again. New laws from the end of last year, new laws that began on January 1st. So we're going to talk about the workers' compensation presumption, your various reporting requirements, the FFCRA, and then we've been getting a lot of questions lately regarding vaccine issues. So we'll talk about that, even though I think most people are not in any category where they're going to get a vaccine anytime soon. So let's start with SB 1159. You may recall that toward the end of last year, Governor Newsom issued an executive order that talked about a workers' compensation presumption. And so the legislature codified that and made some changes to it. So we're going to tell you a little bit about that. So for purposes of workers' compensation, there is a presumption. Hold on, wait. I think I have to go back one. There's both a presumption plus there's reporting requirements. And this law is going to apply to employers of 5 or more employees. And then there's a specific part of the law that pertains just to certain kinds of healthcare providers and first responders and things like that. So we're not going to go deeply into that part of the law. We're just going to talk about the regular presumption. So an employee is going to be presumed to have contracted COVID-19 in the workplace for purposes of workers' compensation if there is a positive test within 14 days of them performing work at the employer's place of employment, and the positive test occurred during an outbreak at the employee's specific place of employment. The date of injury for purposes of workers' compensation is going to be the last day they worked at the place of employment prior to the test. So for example, if they worked on a Friday, they were out Saturday and Sunday, they get the test on Monday, then that Friday is going to be the presumed date of injury for workers' comp purposes. There's some definitions that go along with that. So the specific place of employment is the particular building, office where the employee is performing work. And that work has to be at the employer's direction. So for example, if you say, hey, everybody has to telework, don't come into the office, blah, 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 and the employee comes in, that's not at your direction. And so there would be some issue as to whether that would be protected. The other thing that's important about that specific place of employment issue is it excludes the employee's home or residence. So if you have people out telecommuting and they catch COVID-19 from their husband or children or whatever at home, that's not going to be your workplace. The other thing that the law defines, and of course, none of the laws that were enacted define things in the same exact way, right? So this is for purposes of SB 1159 and reporting to your workers' compensation claims administrator. An outbreak at your workplace is going to be defined by the number of employees you have. So if you have less than 100 employees, it's 4 positive test results. If you have more than 100 employees, it's 4% of the employees who reported positive. And this is, keep in mind, positive tests within 14 days. Okay, so what we've created is a presumption that the employee caught COVID in the workplace, and that's for workers' compensation. You can dispute that presumption. And you can do that with evidence of workplace measures that you've taken to reduce transmission. So this is something that is so important, obviously, first of all, to have those measures in place, social distancing, masks, sanitation, all of that stuff that you should have in place in your workplace to make sure that your employees are not giving each other COVID-19. But almost as important as having those measures in place is documenting those measures. And this is one place where your documentation of the measures that you're taking may come in helpful. As you know, under the California guidance, you're supposed to have a worksite specific COVID-19 plan. And that plan is going to have these measures in it. Social distancing, I'm cleaning everything up, I'm training my people. It should also be in your IIPP. So I am training people, I'm investigating hazards, I have measures in place to deal with these things. All of those written documents that you're creating, that you're taking the time to create, because they are time consuming to do that, are going to be your evidence in various scenarios that you're complying with the law. So super important to document, as always, in employment law. The other way to refute the presumption is to show that non-occupational risk could have caused the employee's COVID-19. Obviously, if their family gets it at home and they're teleworking, there's no chance they got it from your workplace if they haven't been in your workplace, things like that. So the employer has 45 days from the date of the claim to deny the claim. And if the employer doesn't deny the claim, then the employee gets benefits. Okay, so when are you required to report? You're supposed to report to your claims administrator, your workers' comp claims administrator. And the reason that you're reporting to your claims administrator is so that they can determine whether an outbreak has occurred in your workplace. So you must report to your claims administrator if you know or should know that the employee tested positive. You have to do that within 3 business days. Failure to report, false or misleading reporting can cause the labor commissioner to want to issue a civil penalty to you. And what must you report to your claims administrator? These various things. The one thing you don't report is the employee's name. So just if an employee tests positive, the date they tested positive, all these things. And the interesting thing, of course, is that this is all about when employees test positive, and whether or not you can require tests of your employees is quite ambiguous. And we're going to talk a little bit about that. But these are the circumstances in which you need to report to your claims adjuster. So I have a question on a Q&A that says, is testing positive evidence enough, or does the employee actually have to show symptoms? I think it has to be, under many of these laws, it's a very particular test that needs to be taken. And I'm not going to get into that today, but I think that as a practical matter, if you receive a report that there's a positive test, you should report and just assume, because truly what you want is for your workers' comp to kick in, right? Because then you don't have claims in civil court and it's handled within the workers' compensation forum. So how do you determine if an employee caught COVID at work if they work remotely and occasionally on site? And as a practical matter, you can't. And that's why this presumption exists, right? If you have an employee that's going to, house parties on New Year's Eve with 100 people there, it's quite possible that they caught it there rather than in your workplace. So that's why this presumption exists. COVID-19 reporting requirements from AB 685. And this one is more about what you have to communicate internally to your workforce. This is not with respect to your insurer. So this law is effective until January 1st, 2023, as was the last one. Apparently, January 1st, 2023 is a magic date where all of these laws disappear, and hopefully by that time, so will COVID. So your obligations under this law are if you receive a notice of potential exposure to COVID-19, or if an employee has COVID-19. So notice of potential exposure is important because it doesn't require a positive test. It just requires a quote unquote qualified individual reporting to you that they potentially have COVID-19. So if you receive such a report, and we'll talk about that, you have to provide written notice within 1 day to all the employees who are at the same work site as that qualifying person within the infectious period. The infectious period for this law is 10 days. The infectious period under the last law was 14 days. So you begin to see how none of these laws are at all in conformity with one another. So my suggestion would be, as a rule of thumb, to be the safest in your reporting requirements and go with the standard that is going to keep your workplace the safest. And so I would go, you can see that as it comes up, you can make those determinations. So who do you have to report to? You have to report to your employees who may have been exposed to COVID-19. You need to report to the employer of subcontracted employees. And to me, that is like if Apple One is sending you temps, or you have a staffing agency or something like that where you have subcontracted employees, you have to report to their employer. And if you are in a union situation, you have to report to the union that represents the employees. So who is a qualifying individual? It's an individual that has a laboratory confirmed case, a diagnosis. And of course, we're never asking our employees about their diagnosis. Sometimes employees share their diagnosis with us, and that's okay. But we never particularly ask for those things overtly. Or if your employee has been ordered to isolate by a public health official due to COVID, or if your employee has died due to COVID. And this is the various ways in which the notice can come to you that you have a problem in your workplace that you need to report. So your written notice to your employees needs to be given in the same manner that you normally communicate employment-related information to your employees. So if you normally send emails, then send an email. If you usually make text messages or phone calls, do it that way. I'm not a fan of text messages for reasons that I could go into for hours on end and won't do so here. But you need to do it in a way that is your standard way of communicating various employment policy issues to your employees. Don't disclose the identity of the person with COVID. That's like rule number one, always in everything. The identity is sacrosanct because, as you know, in California, we have a right to privacy in various things. And we're going to talk a lot more about that as we go forward. And you're supposed to maintain your records of that notice for 3 years. There are also particular things that have to be in the notice. And a lot of times people that receive notification that their employee has COVID are kind of, wow, what do I do? I got to deal with this. You only have 1 day to do it. You're a little bit under the gun to try to make sure that you're complying with all of the different things you have to comply with. And so keep in mind that there are very specific things that you need to communicate. For example, your disinfection and safety plan, which of course you have documented in your worksite prevention COVID-19 program that you have in writing. So you can just shoot that off with your email if you have that in writing. Please see attached. This is all the information. And it should also be in your IIPP. You also have to tell them about whatever benefits, if they have sick leave or vacation that they can use, or they can telework because they're not so sick that they can't work, but they just have to stay at home. All of that kind of stuff you need to include in the notice. And you also have to note the anti-retaliation and anti-discrimination provisions of the law. You also have a reporting obligation to the local public health agency within 48 hours of an outbreak. And of course, once again, does the law define outbreak the same in this law as it does in the law that we just talked about? No. In this law, an outbreak is 3 people. So for reporting to your employees, an outbreak is 3 people. In reporting under the prior law, which was to your claims administrator, an outbreak is 4 people. So keep those in mind. And then there's particular things that need to be in that notice. And all of this discussion may cause you to say, hey, Cass, we're talking about my employees having COVID. Can I make them take a COVID test? And the answer under California law is very ambiguous. The EEOC has come up straight up and said you can have a mandatory test, but that's federal law. And as you know, we live in a special place that has special rules. And we also live in a place that highly values employee privacy. You'll note that under the OSHA regulations, certain kinds of words are used. For example, an employer should offer testing. And if there's an outbreak, an employer must provide testing. These words, offer, provide, are not require, mandate, right? So you must gently lead the horse to water, and hopefully they will drink. And so that's how it works in California. And important thing to keep in mind is that the same sorts of things that you're thinking about in the context of, can I require a test, are the same sorts of things that you will be thinking about in the future in the context of, can I require a vaccine? So keep those things in mind. And the other thing that this law does, AB 685, is that it allows, it defines certain things that OSHA can do. So when OSHA can issue citations, et cetera, et cetera. And of course, in the context of dealing with OSHA, you want to have everything documented, just as I have been saying for the last 20 minutes or so. You may be wondering to yourself, hey, what's going on with the FFCRA? The FFCRA expired on December 31st, 2020, which means that also its paid sick benefits expired on that date. And you do not have to offer said benefits into the future. But you may offer those benefits, and that's important. You can offer those benefits until March of this year. And you think, well, gee, why would I want to offer paid sick leave to my employees? Well, first of all, there is a tax credit for that. And while it is not guaranteed, it is something to think about. It's not a bad thing to offer sick leave if you're going to get a tax credit out of it. And the other, perhaps more important reason to think about offering it is if you offer paid leave to your employees, they will tell you if they're positive and they won't come spreading COVID throughout your workplace, which is a really good thing because, if you have one employee come in and infect 50 employees, you may be dead in the water on production in the future. So think about whether or not you want to actually discontinue offering that paid sick leave. There's a lot of good reasons to keep it in place if you can do that. And I'm gonna hit the questions that I'm getting before I pass it over to Alex. So one of the issues that's kind of in vogue that we're getting a lot of questions about is whether or not an employer may require employees to get a COVID-19 vaccination. And I only anticipate that this is going to ramp up as those vaccinations actually become available to ordinary human beings like me. It seems like when I look at the list of people who get to get a vaccine, I am at the dead bottom of that list. And I think you're probably in the same boat with me, most of you. So guidelines suggest from the EEOC, which keep in mind, again, we're under federal law with the EEOC, that employers can mandate employees to get the COVID-19 vaccine, okay? As we know, California has strict privacy rules. California's laws in the context of testing use these soft words like an employer must offer, an employer must provide, right? They're not words of an employer must obtain, okay? And that's true even for requiring COVID tests before coming back to work. I mean, the guidelines for OSHA, Cal OSHA say it's not required to have a negative test result before coming back to work. So the federal law is quite different, but the kinds of things that are exceptions to the federal law, like circumstances where you cannot require a vaccine, are also the sorts of things that you should be thinking about in the context of requiring your employees to get tested or requiring your employees to get vaccines. And the two primary exceptions to the federal law are for disability and for religion. So exemption 1 is for disabilities. Obviously, when you go to get a vaccination, they ask you all these questions. And the one that always hits me is, are you allergic to eggs? Apparently, eggs are an integral part of most vaccinations. And so if you say, yes, I'm allergic to eggs, then potentially you can't get that vaccination because it'll cause you to blow up like a balloon and go into anaphylactic shock, right? So are you going to require your employee to get the test under those circumstances? No, you're not, because that would be a medical condition or disability. So that is controlled under federal law by the ADA. As you know, California has its own analog to that. And under the ADA, you are permitted to exclude an employee from the workplace if they pose a direct threat to the rest of the workforce. And so when I think about this in the context of COVID vaccines, who would be a direct threat? Well, first of all, under OSHA guidelines, any COVID infested employee is going to be a direct threat to the other employees. So particularly, I think in the context of like somebody who works in a nursing home, right? That guy that works in the nursing home is really a super direct threat because he's also dealing with people that are particularly susceptible to death by COVID. But then when you start thinking about it further in the context of vaccinations, if you're vaccinating all of the people first that are in the nursing home, and this guy has a disability that prohibits him from getting the vaccine, but everybody else in the workplace has a vaccine, then perhaps he's not a direct threat anymore. And so you can see that as a general matter, this kind of inquiry that is performed under the disability laws is very employee by employee specific, case by case specific. And so it's there's no quick answer, and you have to do an analysis in order to figure it out. And of course, the same rules apply with respect to reasonable accommodation. Check out the essential functions of their job, see if there is some sort of accommodation that you can provide, and you go through that same analysis under the ADA. And this is more of the same. Some of the things that mitigate the threat is remote work, keeping them separate from other employees, all those same things that you're doing now to try to prevent transmission. The other exemption for requiring vaccines is going to be people with a religious belief. There's a lot of religions that do not allow for medical interventions. And so, of course, you would then do the religious reasonable accommodation analysis to determine whether or not you could accommodate the person with that religion. And again, it's the same step-by-step process that you go through, similar to under the disability laws. The other thing that's really important is that if you're going to require somebody to do something in the context of religion, it has to be job related and consistent with business necessity. Finally, we're talking about confidential medical information all along. Again, federal law is quite different than state law. Under the EEOC guidance, you may require proof of a COVID-19 vaccination, but because we're in California, there's nothing that says that you may require such proof. And in fact, OSHA standards say you can't require testing, at least, to come back into the workplace. So it's going to be likely that you're not going to be able to require a vaccination in order to come back to work. So always keep in mind this tension that exists in California. And, you know, the offer of a test is a lot of times enough. Employees will go get that test because they want to know too. And so if you provide the opportunity for testing, it's quite likely that they will tell you that they received a negative test or that they received the vaccination, if you make those things available to them. I'm going to hit a couple of questions. So what if your employees work both remotely and occasionally on site? How do we know that they caught it at work? The answer is we don't know that. That's why the presumption exists. If you allow them to work entirely remotely, then you have an ability to rebut that presumption. Let's see what else. Are these laws dependent on the color or the tier of the county? Are we being encouraged to continue remote work indefinitely through these laws? So they're not dependent upon the tier of the county. They apply regardless of that. Generally, almost everything I've talked about has little to do with the actual tier of the county. Are we still encouraged to continue remote work? And the answer to that is yes, for a variety of reasons. It'll protect your workforce if you are able to have that remote work going on. Yeah. And let's see. Yes, if an employee, another question, if an employee who exclusively telecommutes has informed me that they tested positive, the notification requirement does not apply. The answer is that's correct, because they need to be within your workplace. If they're working at home, they're not going to infect any of your other employees. And I'll hit some of these rest of these questions at the end. I feel like I've been monopolizing this conversation entirely. And so I will then turn it over to Alex.
Thanks, Cass. So I'm going to talk today about 3 new big leave laws that went into effect on January 1st. The first and probably the most important one is SB 1383, which expands the California Family Rights Act. The second is AB 2992, which expands crime victims leave. And then the last law is AB 2017, which really just clarifies some designation issues with sick leave. So again, the first new law is SB 1383, which greatly expands the California Family Rights Act and is a big new obligation for small employers who previously didn't have to comply with this law. So just briefly for background, the CFRA requires employers to provide their eligible employees up to 12 weeks of leave, either to bond with a baby or to care for a family member with a serious medical condition. To be eligible as an employee, you need to have worked for that same employer for the last 12 months and have at least worked 1,250 hours. So that was the case before. That's also the case now. But again, the big change is that the law now applies to small employers too. So before, you only had to worry about this if you had at least 50 employees, whereas now you've got to worry about this law and complying with it if you have 5 or more employees. And another big thing that SB 1383 does is that it expands the family members who can be cared for during the leave. Before, it was just minor children, parents, spouse, or domestic partner. But now the definition of covered family member is broader. So you can also take leave if you're an eligible employee to care for even an adult child, a grandparent, a grandchild, or a sibling. So the next new leave law is AB 2992. And this expands eligibility under the prior Crime Victims Leave Act. And so previously, leave under the law was limited to victims of domestic violence, sexual assault, or stalking. So pretty narrow category. The law is much broader now. And so it also applies to victims of crimes that caused physical injury or that caused mental injury and a threat of physical injury. The law also expands eligibility in that employees are protected if they need leave if an immediate family member has died as the direct result of a crime. And something to keep in mind is that crime is defined very broadly. There doesn't necessarily have to be someone arrested or prosecuted or convicted of the crime, and the crime can still occur outside of California, and the employee would still be entitled to leave. Keep in mind, though, in the slide doesn't contain this, you can ask your employees for documentation about the crime. So that would come in the form of a doctor's note, court order, a police report, or a certification by the employee confirming that the crime occurred. So the last new leave law is AB 2017, and this is really just a minor change, I think. So under California law, this again was the case before and is the case now. Employees can use half of all their accrued sick leave to care for a family member, and this, of course, is known as kin care. So this law was passed just to prevent designation errors, and it clarifies that only your employees can designate whether their leave is being used for kin care or for personal sick leave. And that's just to avoid the employer inadvertently drawing down the kin care leave that's available. So switching gears a little bit, there are also some new developments in the realm of discrimination, equity, inclusion, and privacy issues. And the first big law on this issue is SB 973, which is a big, I would say, big new burden for large employers. It's a new pay data reporting law. So now if you're an employer with over 100 employees, you must report pay data and hours work data by sex, race, and ethnicity to the DFEH. The purpose of the law is to reduce pay discrimination and to, bolster awareness based on the employer having to, collect and put this data together and then report it to the DFEH. Because the law is new, the first reporting deadline will be this March for large employers. And at that time, you would report your pay data from January 1st of 2020 to December 31st of 2020. And then next year, you would be reporting your 2021 pay data. Like Cass said, privacy is always important. And so when you report this data, individually identifiable information should still be kept confidential. Something to keep in mind, the DFEH is going to provide more guidance on this law. It's not quite up yet. Their website indicates that it'll have a user guide and a template for employers up by next month. So hopefully that'll provide some more guidance as to how to submit this report to the DFEH. So I won't cover everything in this slide. It's good for future reference if you are one of the large employers with over 100 employees who needs to meet this reporting requirement. I'll just touch on the highlights. So again, you need to report data by race, ethnicity, and sex according to 10 different job categories. And those categories range from senior level managers, professionals, to technicians, or sales workers. It's quite a range. And then you also need to give, as part of the report, a snapshot of a certain pay period showing what those employees made. Again, that's by race, ethnicity, and sex. On top of that, you also need to report where employees fall in each pay band. And we'll have a slide, I think in a couple more, that shows those salary ranges. The report also needs to report total hours worked by the employee. And then you have the option, if you have multiple establishments in California, you can report by establishment or you can submit a consolidated report. So this covers some more of the technical requirements. You need to submit the employer's address, its headquarters, whether or not it's a state contractor. You can also provide clarifying comments on the data that you're submitting. And I would think closely about that on a case-by-case basis. Maybe there's something, you feel like the data indicates men are being paid more than women on a certain category. Maybe you think about a clarification on that. But again, that's really a case-by-case basis to think about that closely. And then the last couple technical requirements, you have to certify that the report's accurate, of course, and then you need to also provide contact information for someone if there are questions on your report. So here are the BLS pay bands that I had mentioned before. There's 12 of them. You know, they range from under about 20,000 to over 208,000. You can see the bands, the lower the amount, the smaller the band is. So that, you know, second band, it's only about a $5,000 range, whereas you get to that second to last band, it's almost $40,000 in range. So that's something to keep in mind. And again, those are all, those statistics are from the Bureau of Labor Statistics in terms of how you comply with the bans. So a couple other notes on SB 973 for teleworkers. If you have an employee who's working out of state right now, they're still considered a California employee. So you've got to include them on the report. And then if you have the opposite situation, you're an out-of-state employer, but someone's working here in California, you can either report only on the California workers, or you can report on all the employees working for the establishment. And then a couple last notes for race and ethnicity. The DFEH recommends following the EEOC's instructions. And then for sex, it's preferably self-reported according to 3 different categories of male, female, or non-binary. So again, it's a bit of a work in progress. Stay tuned. The DFEH should have some more guidance on this, but if you are a large employer, this could be a big new deadline that you'll need to comply with in just a couple months. So there were also a couple big discrimination and Equal Pay Act cases that came out in 2020. The first is the Ninth Circuit's decision in Yavino. And there the Ninth Circuit held that under the Federal Equal Pay Act, employers may not justify a salary gap between men and women based on what someone made as part of their prior salary with a different employer. And this is consistent with California law. And I think it's also pretty intuitive how the court reached its decision. Its thinking was that, you know, a pay disparity based on prior salary is not job related. And if anything, that could perpetuate pay discrimination by locking in lower wages that were earned due to discrimination at a prior job. And so the court looked closely at what's known as a catch-all factor under the Federal Equal Pay Act, which allows for disparity in pay based on any factor other than sex. And it really clarified that if you're going to use this catch-all factor, you really need to have objective criteria for it. And really the takeaway from this case is that if there's going to be a discrepancy, you want to have it be based on something as measurable and objective as possible, such as a seniority system or a merit system or something based on quantity of production. You know, if your employees are making widgets, you can pay them by the widget, and you know, the employee who makes 100 is going to make more than the one who makes 80. And that's something you can more readily justify the discrepancy in pay than something that's a bit more subjective. So the other big case that came out was the Supreme Court's decision in Bostock versus Clayton County. And this was a landmark decision nationally, received a lot of attention. Of course, the case held that gay and transgender workers are protected from discrimination under the Federal Civil Rights Act. And so this was a big issue nationally, but practically speaking, here in California, those workers are already expressly protected under the California Fair Employment and Housing Act. So I think nationally, this, of course, was a big deal. But in California, employers, you know, already knew that those employees were protected just the same as employees are protected based on race or sex. So just a couple more miscellaneous things to keep in mind. AB 979 now has a new requirement for boardroom diversity for corporations who are headquartered in California. By the end of this year, they must diversify their board with at least one member from an underrepresented community. And this law is similar to SB 826, which had mandated gender diversity on boards. So in terms of defining underrepresented community, it would be someone who self-identifies as a racial or ethnic minority, such as Black, Latino, or Asian, or someone who self-identifies as gay, lesbian, bisexual, or transgender. And something to keep in mind, the number of diverse directors required increases over time, and it's also dependent on the size of your board. For example, if you have over 9 board members, by the end of next year, you'll need to have at least 3 diverse members on the board. The last topic I'll cover is Prop 24, which expanded and updated the Consumer Privacy Act. Again, California is very, very big on privacy, but relevant for our purposes. Prop 24 extended the exemption for employee personal information until 2023. Again, that big year that Cass referenced before. So this allows employers to still collect and use certain pieces of information that they receive from either applicants, employees, or even independent contractors. A couple examples would be, emergency contact information or information needed to administer benefits. And then keep in mind, despite the fact you can collect this, you still need to have prior contemporaneous notice before using that data. And then with that, I'll turn things over to Liz.
Alex, before we move on to my section, did you want to answer? There's a question that came in, I think, on your section.
So does the diversity requirement include nonprofit boards? It does. The key question is if they're headquartered in California. And then you also want to look, I can go back a slide, I think.
You probably can't because I have control of the slides.
Oh, no. If you look back, though, there's that specific definition about domestic or foreign corporation. So that's really, you want to, if you fall within that definition and you're headquartered in California, you should be complying with this new diversity requirement. So the other question, if employees don't have to inform you what sex or race, how do we accurately report that? That's a good question. So those are the recommendations. Hopefully there'll be more guidance on that. It's certainly one of those sort of leading the horse to water, like Cass said before. You can ask them for it, you can't mandate it, and you just work on accurately reporting the data that's voluntarily given to you. But of course, don't force employees who are not willing to disclose that data to do so.
Hi, everyone. I will be closing out the last portion of today's presentation. As perhaps you figured out by now, the pandemic has not kept our courts or legislature from continuing to change the rules for us moving into 2021, and wage and hour issues are no exception. And so these are the 4 general topics I'll be covering today. One is, and we start with this every year, I believe, minimum wage increases for 2021. Next, a couple of new legislative requirements with respect to rest periods for particular industries. Then talk a little bit about some of the changes that have occurred for 2021 with respect to independent contractor classification, which has been something we've been talking about, I think, every year since at least 2018. And then some updates on 2 cases, a pair of companion cases from the California Supreme Court, Ward and Oman, which, although they're specific to the airline industry, I think give us some bigger issues to think about with respect to employees who aren't necessarily based in California, or essentially California's reach into organizations outside of the state with respect to what kind of wage and hour obligations you might have. So with that overview, we'll go ahead and start with the minimum wage increases. As perhaps you remember, due to legislation passed, I believe 3 or 4 years ago, we've been gradually moving toward a $15 per hour minimum wage. That will go into effect as of 2023. In the meantime, as of January 2021, we've moved up again to $13 an hour for those employers with 25 or less employees or fewer employees, and then 14 an hour for those with 26 or more. We put in here also 2022, again, we'll follow that same progression. And again, ultimately, we'll get to $15 an hour for everyone. Again, we always stress this as well. It's really important not just to look at the standard for the state level, but to remember that there are different requirements for various local jurisdictions around the state. By way of example, and I wrote a few of them down, Los Angeles is currently at $15 an hour already for 26 or more, and $14.25 for 25 or below. Berkeley and San Francisco are at $16.07, and Santa Rosa's at $15.20 already. Emeryville $16.69. Just the point being, make sure that you pay attention to the locality where you operate. These local increases exist all over the state. There are various ones in Southern California as well as in the Bay Area. And then the only other thing I would point out with respect to the local increases is, unlike the state level increase, which kicks in on January 1 of each year, these local ordinances oftentimes kick in July 1st. So for example, in Los Angeles, that's carrying over from where they went July of 2020. Then in July of 2021, we're going to see another increase. So certainly if you're dealing with the locality, make sure that you pay attention again and you know whether or not it's going to change for you mid-year. Next, the industry-specific rest period rules. This really, to start with the policy rationale, obviously there are certain jobs where it may be difficult for the employer or even unsafe to completely relieve their employees of all of their duties during a rest break. As no doubt you are aware, the general obligation with respect to a rest period is that that employee is off duty and not being controlled by their employer. So these are responses to specific situations where that general policy may not be prudent, may not be appropriate. And the first of those comes out of AB 1512 and deals specifically with security guards. Here, it's going to provide that certain unionized, and that's important, private security officers, you can require them to remain on premises during their rest period, and you can also require them to remain on call and carry and monitor a communication device during rest periods, presumably if an incident occurs while they're on their rest break. Here again, and obviously this no doubt, if this isn't your industry, it doesn't apply to you, but just generally speaking, I wanted to walk through some of the requirements just so you can see that the legislature isn't providing this exception lightly. Again, they're requiring that it only be for certain registered employees and employers, that those employees are covered by a collective bargaining agreement, and that the collective bargaining agreement covers certain general requirements with respect to protecting the wage and hour rights of those employees. So again, it's even in being a specific industry exception, it is also specific as to which individuals in that industry can be accepted. The only note on that as well, if this is applicable to you, we see in the legislation that they're still requiring, for example, if one of those designated employees is interrupted on a rest break, the employer is still going to have the obligation to provide an uninterrupted rest break as soon as the emergency subsides effectively. That once it's reasonable to let them go back on a break, they can go and continue and essentially restart their uninterrupted 10-minute break. And of course, if that's not possible and you don't meet the requirements of California law, for 10 minutes for every 4 hours or portion thereof, then you will still be required to pay that rest period premium of the hour's pay for missing the break. This may all sound familiar to you. Back in 2016, and I think we've spoken about it in a prior update, there was a case that came down with respect to security guards and rest periods, Augustus v. ABM, that ruled that certain on-call rest periods didn't comply. Essentially, in that case, because they were requiring the employee security guards to remain on call, it wasn't considered to be an actual off-duty rest break. And so this legislation is essentially a response, to the mechanics of complying with that requirement. And some of the things we see in the legislation, not surprisingly, are things that the court indicated in its opinion could be a possible option, such as providing the rest break later, things like that. And just briefly, I'll say that there was another exception carved out for certain petroleum workers out of AB 2479. Again, very similar to what we just discussed. It's extending that exemption. It's allowing these workers to be able to respond to certain emergencies. And then same kind of requirements. If they are interrupted during their rest break, when they're on call, then there's this obligation, if you can, to let them take an uninterrupted rest break when that emergency subsides. And of course, if you can't comply with that obligation, then you have still that obligation to provide the rest period premium. Again, this may not apply to your industry. I just think it's noteworthy with respect to not only confirming, we know the off-duty requirements of rest periods, and the legislature is being very careful about when they're carving out exceptions to them. So next, independent contractors, another topic we spend an awful lot of time talking about around here. What's happened since our last annual update? First of all, we have AB 2257. That attempts to clarify AB 5, which of course in turn was trying to codify and clarify the Dynamex decision. Just briefly, the Dynamex decision came down in 2018, and it involved a class of same-day delivery drivers that claimed that they had been misclassified as independent contractors instead of as employees. The Dynamex court confirmed that in fact that was true and really shifted the focus of the independent contractor test from being on the control of the hiring entity to then instead imposing the ABC test, which is detailed here on this slide. AB 5 went on effective January 1, 2020 to codify that test and make it applicable in the state. So what's the ABC test? You as a hiring entity, in order to demonstrate that you have an independent contractor and not an employee, have to have someone who is A, free from control and direction of you as the hiring entity, both under the contract and in the actual performance of the work. And again, that control test is where we used to live in these decisions, but that's now just one prong. And then B, that the work being performed is outside the usual course of the hiring entity's business. And C, that the person is customarily engaged in performing work of the same nature as an independently established trade, occupation, or business. So again, we've been dealing with the ramifications of complying with this change. AB 5, when it went into effect, carved out certain exceptions, certain individuals within industries, and also certain industries from the application of this requirement. AB 2257, again, Dynamex was codified by AB 5, but also carved out certain exemptions. It's important to remember, if you are exempt or the kind of worker is exempt under AB 5, then we go back to that older Borrello test, which is essentially the control test, right? We focus on whether or not the hiring entity has the right to control the worker, which is where we were before Dynamex came into effect. So now we go to AB 2257. This legislation, and not surprisingly, AB 5 raised new questions and new issues with respect to who was exempt and who wasn't exempt from the obligations. There's also been various litigation about certain classes of workers who were not made exempt from AB 5's application. So in some respects, AB 2257 is an effort to try and fix some of those ambiguities and address some of those concerns. It clarifies the business-to-business, referral agency, and professional services exemptions. And it also exempts additional occupations and business relationships. For example, there are quite a few issues addressed with respect to creative occupations, freelancers, music industry, things like that. Now, after AB 5 and AB 2257, there are 109 categories of workers exempt from the ABC test, now in effect as of January 1. So of course, our takeaway from this, it's important that you evaluate the applicability of these new provisions. Make sure you know if even something that before wasn't exempt is now exempt as of 2257's enactment, and you understand if with respect to that relationship, you need to be applying the ABC test as indicated by Dynamex and the subsequent legislation, or if you have to apply the Borrello control test to figure out whether or not that person is an independent contractor or an employee. So speaking of independent contractors, as no doubt you are aware, there was a significant movement with respect to app-based drivers, Lyft and Uber drivers, and that came to a head with Proposition 22. It passed in the state of California. What it does is it classifies those drivers. So again, not just your Uber and Lyft drivers, but also those sort of gig economy delivery companies, Postmates, DoorDash, Instacart, things like that, as independent contractors and not employees. Of course, the reason they went for the proposition was because absent this clarification, those kinds of workers were not exempt from the requirements of the ABC test. And in applying those requirements, those workers were going to be found to be employees, which would have significantly impacted these businesses. So other things to note about the application of Prop 22, there are certain other provisions in there with respect to required labor and wage policies for these workers. For example, there are certain protocols for now providing, as we've listed here, certain kinds of training and policies. There's now certain triggering points where, based on how much time this worker spends providing the service, they may qualify for some sort of healthcare stipend, which they can then use to purchase health insurance. Some of this we see as a response to the criticism that this industry faced, because by classifying them as independent contractors, they were not receiving the standard protections of employees. This proposition provides some of those, but certainly doesn't provide others. For example, it's not requiring health insurance. It simply has a bucket of employees who, if they meet that minimum number of working hours, will then qualify to receive a stipend. I think it's important to note that like app-based drivers, another industry that's been fighting the AB5 impact is the trucking industry. They are, not only were they not carved out in AB5, they're not carved out in the recent legislation that just went into effect this year. And so there are still some industries that are fighting to be, for lack of a better word, exempt from the ABC test. That trucking industry litigation, I believe they had oral argument in the Ninth Circuit in the fall of last year, and that hasn't been finally determined. So I guess the punchline from that is don't be surprised if we're talking again about independent contractor classification issues in our next year's update, because these are still being worked out. And I think that the change in legislation, this year's legislation, is simply indicative of that as we figure out how this law applies, there's certain industries and certain workers where it just doesn't make sense, or where they haven't clarified how to apply the required obligations. And so we may see more and more of that editing and kind of clarification even in the coming years. So the last section of my discussion on wage and hour issues is to talk to you about two cases that came out of the California Supreme Court. They were companion cases dealing with how to apply and what applies with respect to California wage and hour laws when we're dealing with non-resident employees that are working in the state. And so the two cases were Ward v. United Airlines and Oman v. Delta. As you can no doubt tell from the captions of these cases, we're talking about employees in the airline industry. I believe the named plaintiffs were a pilot and 2 flight attendants. And so issues arose over whether or not the wage statements and the compensation structures for these employees were in compliance with California law, and of course, whether they had to be. So the first is Ward v. United Airlines. This one, again, as I indicated, we had a pilot and 2 flight attendants. They were California residents, and they were challenging United's wage statements under California Labor Code Section 226, which requires employers to provide certain information on pay stubs. And I'm sure many of you have dealt with these issues yourselves. Here, I believe the key issue was whether or not the employer's address was provided. So again, the plaintiffs are asserting my wage statements don't include that street address. And again, here also hours worked during the pay period and applicable hourly rates. Bottom line, these wage statements don't comply with California Labor Code. So the first question addressed by the court was whether or not an exemption in the applicable wage order for these employees and for these employees under a collective bargaining agreement would prevent them from pursuing these claims for wage statement violations. Not surprisingly, the answer was no. The analysis the court provides is essentially that the legislature had the ability to carve out an exemption for complying with 226 in the labor code provision itself and did not do that, even though it's had the opportunity to do so. And so the court is going to look at that as evidence that the legislature did not intend to provide that exemption and to enforce the requirements of 226, notwithstanding the existence of a collective bargaining agreement. Now, of course, this becomes an interesting issue because there are various industries that operate nationwide that may believe that a nationwide collective bargaining agreement can be uniformly applied to all employees. This, of course, raises a question with respect to whether or not that's going to be the case for California. Certainly in this case, it's not. The next question addressed by Ward, does Section 226 apply to wage statements provided? And this is a pretty detailed situation. An out-of-state employer to an employee who resides in California receives pay in California and pays California income tax on those wages, but who does not work principally in California or in any other state? And here, the answer, as best, as we often do in legal situations, is maybe. It depends. And so a few of the takeaways under this principal place of work test, we look at things like, is the majority of the work that they're performing during the pay period in California? And if that's not applicable, maybe we have someone who the majority of the work isn't done in any particular state. Do we look at whether the employee is based in California for work purposes? What's interesting about the court's answer to this question is they essentially deem that a lot of other issues listed in here, for example, are irrelevant to that calculation. We have to focus on the principal place of work. So then we have the other case, Oman v. Delta. Here again, we had flight attendants, they had filed an action. And in this case, they were alleging that the compensation structure that Delta provided for them was unlawful. And so here, you can imagine a flight attendant is on they fly certain flights, they have a certain schedule. The way their compensation was identified in their collective bargaining agreement was that they received a payment by the rotation, right? The particular shift almost that they did, rather than breaking it down by the hour. And of course, they were also looking at whether or not Delta had corresponding failures to comply with other provisions of the labor code, such as pay period requirements and compliant wage statements based on the way that they were being compensated. So here again, here was our first question. Do those provisions of the labor code apply to wage payments and wage statements that are being provided, again, an out-of-state employer to an employee who in the relevant pay period works in California only episodically or for less than a day at a time, right? So someone who isn't based in California, not surprisingly, again, we get an answer from the court, maybe. And so we again see this issue where the court is looking to define when California's reach can apply to even an out-of-state employer with an arguably out-of-state worker, or at least only a nominally in-state employee, as would be the case with these flight attendants maybe coming in and out on the way, flying in and out of the state. And then the next issue, does California's minimum wage law apply to all work performed in California for that out-of-state employer by this employee who, again, works only in California episodically for less than a day at a time? Here, the court basically punted answering this question, as we've indicated, because it didn't get into deciding what the reach of the state's minimum wage laws are. And of course, that leaves that as an open question for us to wrestle with in other industries. And as we move forward, especially with this trend toward California taking more control over operations of out-of-state actors within its own state. So here, the third question, does California's case law against averaging wages apply to the pay formula that was being used by Delta here, which essentially was giving them credit for every hour they worked, but was not giving them this sort of hourly pay because they were paying by rotation? And here, the court found that the Delta wage structure was not unlawful and talked about something called the wage borrowing rule. And so just briefly, so to explain what that refers to, imagine a scenario where someone was paid on a shift where 4 hours of the shift, they were paid $20 an hour, or let's say $40 an hour, we'll keep it easier. And then 4 hours of the shift, you're paying them $3 an hour, obviously less than the minimum wage. Wage averaging, you would be borrowing the above minimum wage time to get there and make sure that they were getting paid a sufficient amount per hour. California is not in favor of that. However, in this case, they said because the structure wasn't an hourly structure with different rates, essentially it was based on a rotation where they were doing different things at different times, the court was going to allow that as an appropriate, albeit unique, way of compensating them that wouldn't run afoul of the minimum wage laws. I assume here that a little bit of what we're seeing is also a reflection of the fact that there was a collective bargaining agreement in place and they had negotiating power with respect to the compensation they were receiving. So finally, again, as we've kind of walked through, just to refresh, why is this important? I appreciate if you don't run an airline and you don't have flight attendants and pilots under your employ, you might think, why are you telling me this? Again, the key takeaways, I think, have more to do with an indication as to California's willingness to start reaching further and further and kind of confirming its oversight for employees and activities that wouldn't necessarily be default California otherwise. So first, of course, we see they weren't willing to provide a wage statement exception for those individuals subject to the CBA that was nationwide. As I mentioned earlier, I think that has implications for any national or even multi-state employers who might be relying on a standard practice for all employees. Of course, what's interesting here too is we don't know how this impacts other California requirements such as wages that weren't addressed by the court. But again, there's this indication that the courts are going to look at these things and lean toward applying California obligations and enforcement under California's scheme. The second takeaway, we look at this issue of balancing, principal place of work and having to do that sort of in-depth factual analysis, making sure we understand whether or not it's a situation where California's requirements are going to apply or not. To me, that's the kind of thing where if you're looking at those kinds of employees or you have a question, it's a fact-specific analysis. It requires some individual focus. I don't think you can just assume one way or the other. And honestly, based on some of the application of the court decisions, you may be looking at that on an even more intermittent basis, such as every pay period, right? If you have someone who is moving around and doing work in multiple areas as part of their job. And then finally, and I won't make you go through this whole thing, but just to point out that there is certainly an indication that there's a non-traditional compensation structure, that rotation structure, that the court found to be acceptable, even though arguably every hour may not have been paid at minimum wage. And again, here we have this guidance with respect to when such a structure would be acceptable to the court and under California law. So again, if you have some sort of unique compensation structure, it makes sense to look at this kind of question and to ensure that at least the best you can, you're falling into the bucket of something that would likely be deemed acceptable. We've dealt with this quite a bit with things even like piecework over time, and certainly there's some of you out there that have to provide unique compensation to get certain kinds of work done. I think, again, as usual, the takeaway is make sure we look at those structures and make sure we feel comfortable that they're being done in a way that's protective and keeps you from pulling on or getting into a realm where you're going to start facing potential liability because you're not following with the sort of default expectation of how we compensate employees in California. And so with that, that's the end of our primary presentation. And I don't see, apparently I did such a good job that none of you have any questions about these issues. And so I will take that as a good sign. And I will go ahead and thank you all for participating. Remind you again that we will be sending out the slides and making the webinar available for those of you who are interested. We also will stick around for a few minutes if any of you have questions. And of course, if you have any issues with respect to implementing any of these issues or anything else, you know where you can find us, and I hope you will in 2021, and that hopefully we will be seeing you all in person in 2022. And so with that, I will conclude the presentation and thank you, and we'll go and we'll start jumping into any questions that remain.
So I'm going to hop in. One of the questions that I see is if my company took advantage of a PPP loan in 2020 and received full forgiveness, are we still eligible for the tax credit? So first of all, I would congratulate you on receiving notification that your loan is forgiven. I think you are uniquely privileged in that respect. With respect to your question regarding the tax credit, that to me has not fully played out. Even as recently as 2 weeks ago, we were still getting guidance from the SBA on what you can deduct and what you can't deduct. And so I would say for the time being, stay tuned. I'm sure your accountant will be able to assist you with respect to that. But right now it's still ambiguous. Guidelines are still being issued. And so that's the answer to that question. Any further questions? Just go ahead and type them in the Q&As. It looks like we have no further questions. So I would just say thank you for joining us today, and got you out in time to go grab lunch. Sorry we couldn't provide it, but we will be providing it hopefully next year.
Thank you, everyone.
Thanks.